Thank you, Bill. Actually, Bill gave my whole speech, so really there's not much left for me to say. But I am going to talk to you today about Massachusetts v. EPA, which is the case that Bill mentioned. But first I want to say thank you to Dean Jeffries for the opportunity to speak to you, and thanks to all of you for your work in making this institution great and keeping it great over these many years. So Massachusetts v. EPA, decided on April the 2nd, was the court's first case addressing climate change. And the decision was an enormous victory for environmentalists for two reasons, basically. It legitimized their concerns about climate change, and it legitimized their claims that the administration wasn't doing what it should to address climate change. Whether the decision was a great victory for the environment, I think, remains to be seen, and I'll talk some about that at the end. But the decision will certainly figure strongly in the policy debate that will happen over the next several years. For me, as Bill mentioned, the decision had a special personal significance, and I'll talk about that a little and then go on to make some general comments about the court's decision. I'll try to be balanced, but please keep in mind that I do have a dog in this fight, and that will probably be all too obvious as I tell you what I think about the case. So for me, the story begins on a day in March 1998 at hearings before the House Appropriations Committee. The administrator of EPA, Carol Browner, then was defending her budget before the committee, and I was sitting behind her along with a bunch of other of her lieutenants. These are the wooden-faced people you see on C-SPAN broadcasts and wonder what they are doing there. What they are doing is hoping desperately that they don't get bounced a question that they can't answer. That day, something unusual happened. Congressman DeLay was a member of this committee. He came in to the committee room with a document, and he was looking at the document in a way that made it pretty clear that he was annoyed with something in the document. The document, it turned out, was an EPA report, which contained a sentence to the effect that EPA had authority to regulate emissions of a number of substances from electric power plants, including carbon dioxide, a greenhouse gas. And when it came his turn for questions, Congressman DeLay asked the administrator whether she agreed with that sentence, and particularly the unprecedented claim, in his view, that EPA had authority to regulate emissions of carbon dioxide. She answered yes, she did agree, and she would be happy to have me provide a legal opinion on this point. Now, I had never discussed this issue with her before that moment, but there appeared to be no doubt about what the legal opinion would conclude. As it turned out, the opinion was not hard to write. The Clean Air Act says that EPA must regulate a substance if it is an air pollutant, and if the administrator finds that emissions of it will endanger human health and the environment. The statute defines air pollutant with astounding breadth as, and I'm quoting here, any air pollution agent, including any physical, chemical, or biological substance or matter which is emitted into or otherwise enters the ambient air. I think the real question under that standard is what's not an air pollutant. Anyway, I concluded that CO2 and other greenhouse gases qualified as air pollutants when emitted into the air, and that EPA was bound to regulate them if it found that they met the endangerment standard. Although it seemed pretty straightforward to me as a legal matter, this opinion met with considerable skepticism, indeed derision in some circles. There was an ad developed by the Competitive Enterprise Institute that started out with images of, this is a television ad, started out with images of happy people walking in the parks, running on the beach, enjoying their lives in their lighted houses and apartments. And a narrator in the ad comments that CO2 is essential for life and that the fossil fuels that produce CO2 have saved us from lives of back-breaking labor and enabled us to care for the people we love. And then the voice turns a little darker here and says, but now some want to label CO2 a pollutant. What will happen if they succeed? And then there's an image of a young girl. She's innocently blowing seeds from a dandelion head. It's really a beautiful picture. And then that image suddenly goes dark, and there's the punchline. And the punchline is carbon dioxide. They call it pollution. We call it life. And you know pretty much who the we and the they are in that, right? I was the they. In 1999, after I left EPA to come to this wonderful place, a coalition of groups filed a petition to EPA to regulate greenhouse gas emissions from new motor vehicles under Title II of the Clean Air Act. They relied on my opinion as the legal basis for their petition. In 2003, while that petition was still pending, a new EPA General Counsel reversed the 1998 opinion, concluding that the agency did not have authority under the Clean Air Act to regulate greenhouse gas emissions. Did I say that there was a change in administrations during this? So soon after that, EPA denied the rulemaking petition on the grounds that it didn't have regulatory authority to act, and even if it had the authority, regulating greenhouse gases at this time would be unwise. That decision was upheld by a divided panel of the D.C. Circuit, and then, somewhat surprisingly, I think, because there was no conflict among the circuits, and there was a serious threshold question about whether petitioners had standing, the Supreme Court granted review. And then last month, Justice Stevens delivered the opinion of the court, speaking for a bare majority that included Justices Kennedy, Souter, Ginsburg, and Breyer. The court concluded that at least one of the environmental petitioners, the state of Massachusetts, had standing. And on the merits it held that EPA had the authority to regulate CO2 and other greenhouse gases, and that in declining to regulate, EPA had failed to meet its statutory obligations. Chief Justice Roberts and Justices Scalia, Thomas, and Alito joined in a pair of dissenting opinions. Justice Roberts wrote to the issue of standing, and Justice Scalia wrote to the merits. So, what are we to make of the court's decision? An early commentator on the decision said this: a breathtaking result for the Greens. Stunning. The decision defines a major new area of responsibility for EPA, and it places limits on the agency in carrying out that responsibility. It also projects a sympathy with environmentalist beliefs and values to an extent rarely, if ever, seen in the Supreme Court's environmental cases. This cultural or symbolic significance of Massachusetts v. EPA is, for me, the decision's most remarkable feature, and it is to that I will now turn, begging the indulgence of my colleagues who have heard some of the ideas that I'm going to use here in other settings. What do I mean by environmentalist or environmentalist beliefs and values? People calling themselves environmentalists believe a lot of things, but there are some common themes, I think. Environmentalists share a sense of urgency. They believe that the environment is seriously threatened and that it requires attention now. They also subscribe to what I will call the ecological model, the idea that nature is fragile and interdependent, so that environmental disturbances are likely to have consequences, and those consequences may be distant in place and time. In the absence of conclusive evidence of harmful effects, environmentalists tend to presume that such effects exist. Environmentalism is associated with certain values that emphasize acting collectively for the common good and fitting harmoniously into the natural and social environment. Environmentalists tend to favor regulation to prevent or correct the widespread harms that they see in the world. Now, this environmentalist worldview has implications for the law. It assumes serious secondary effects or externalities from environmental disturbances, even though those effects may be uncertain or difficult to measure, and thus it supports steps to control those externalities. And you have Supreme Court justices that have shown some sympathy for this worldview, and those tend to be the same justices that favor liberal access to the courts, a broad scope of federal regulatory power, and generous interpretations of environmental regulatory authority. And you have some other justices who have shown resistance to this environmentalist worldview, and those tend to be justices that have different views on the issues that I just mentioned. Against the claims of environmentalists, these justices place judicial restraint, limited federal power, and narrow constructions of regulatory authority. Now, I don't mean to suggest, and I don't suggest, that justices in this latter category that I've mentioned are somehow anti-environment. They don't wish environmental harm. Their resistance to environmentalism is motivated, I think, mostly by fear of the consequences of the environmentalist vision for individual autonomy and economic freedom. Now, these opposing views are manifest in Massachusetts v. EPA. I don't know whether you've had a chance to read the opinion, but you take the first page of the opinion just smacks you in the face. It starts off in striking fashion with this assertion: respected scientists, that's in quotes, believe that the rise in global temperatures is related to a significant increase in carbon dioxide concentrations in the atmosphere. That's the factual premise for the entire rest of the opinion. The court then quotes environmental petitioners' claim that global warming is the most pressing environmental problem of our time. The prominent placement of that quote so early in the opinion leaves little doubt that the court agrees with it, and the rest of the opinion bears out that implication. So if we assume that the court uses the first page of its opinion to tell us what is most important about the case, the most important things in this case are that anthropogenic climate change is real and that it is very serious. Now, in their dissents, both Chief Justice Roberts and Justice Scalia note the court's sense of urgency. They're careful not to say the court is alarmist. Their point instead is that the court's assessment of the risks, whatever they are, should have no influence on its decision. So even if climate change were a crisis, indeed, even if it were the most pressing environmental problem of our time, responding to it is the job of the politically accountable branches, not the courts. Thus, against the force of environmental urgency, the dissenters would place the barrier of institutional constraint. The outcome here, of course, would be no regulation. We can trace the influence of these competing views more specifically in the justices' positions on the three issues decided by the court. Specifically, the issues were standing, the scope of EPA's regulatory authority, and the appropriateness of EPA's decision not to regulate. So let's take standing first. The standing inquiry focuses on the nature of the injury necessary to invoke the judicial power under Article 3. Larry Walker has taught me the basic elements of the standing inquiry. There are three: injury, causation, and redressability. Got those down, Larry, I think, by now. The injury, we know, must be concrete and particularized and actual or imminent. The injury must be causally related to the legal violation complained of, and the relief requested must be capable of redressing the injury. Now, in his opinion for the court, Justice Stevens goes on at length about the particular merits of standing for Massachusetts as a sovereign state, and I'm not going to get into that. I hope you're not disappointed. I'm instead going to focus on the court's assessment of Massachusetts standing under the traditional three-part standing test. Massachusetts' argument for standing was based on a claim of systemic injury. And the success of that argument really depended on two things. First, the court's readiness to assume injury from human disturbance of a vast and complex system, the Earth's climate system. And second, the court's willingness to accept as significant climate effects that could not easily be quantified and might even be small, relatively small, within the context of the system as a whole. In short, standing in this case depended on a view of the facts consistent with the ecological model, and that is the view that the court embraced in its opinion. So you see Justice Stevens fashioning an extended chain of causation that goes something like this. Domestic motor vehicles emit greenhouse gases. Increased world greenhouse gas emissions have led to a heightened greenhouse effect, which has led to a global temperature rise, which has led to a sea level rise, which has led to a loss of Massachusetts coastline. EPA's failure to regulate greenhouse gas emissions from automobiles contributes to this loss. A correction of that failure will moderate the loss. Hence, injury causation and redressability. I'm not sure that Larry will be satisfied with that, but that's what the court has to offer on the question. It doesn't matter to Justice Stevens that the causal chain is lengthy and complex, or that specific impacts are relatively small or difficult to measure. His analysis accepts the notion that systemic injuries are just as real and serious, indeed more serious, than the discrete injuries that have traditionally supported standing. Now, Roberts' dissent on this issue argues that the court uses, and I'm quoting now, the dire nature of global warming itself as a bootstrap for finding causation and redressability. And his main object here is to deconstruct the court's causation story. So he says domestic automobile emissions are a minuscule part of global greenhouse gas emissions. The linkage between those emissions and Massachusetts coastal loss is fraught with complexity, far too speculative to establish causation, and far too speculative to make it likely that Massachusetts loss will be redressed by any auto emission standards EPA might impose. Now, in this, Justice Roberts insists that he's not debating the scientific case for climate change or doubting its seriousness. He is simply taking Article 3 seriously and applying those standing requirements to keep the courts out of policy and to maintain the tripartite allocation of power. But by pulling apart the several elements of the causal chain and demanding proof for each, his analysis necessarily rejects the environmentalist presumptions of fragility, radiating harm, and serious consequence. We see a similar pattern on the merits issues. These two issues are EPA's authority to regulate and its determination not to regulate at this time. Both of these issues turn on the degree of discretion that the court is willing to grant the agency. The justices' different views on that question are framed by their sense of urgency about climate change and also by their concept of the role that that urgency should play or should not play in the court's deliberations. The court's opinion sharply limits EPA's discretion in dealing, or as the case might be, not dealing with climate change. First, it holds that greenhouse gas emissions clearly fall within the statute's ample definition of air pollutant. Quote, the statute embraces all airborne compounds of any stripe. Second, the court limits EPA's latitude to postpone regulation. Here, the court says, the EPA has to determine either that CO2 emissions from automobiles pose a danger or they do not, or that the scientific uncertainty is so profound that EPA can't come to a reasoned determination on this issue. And the agency, the court says, did neither thing here. Now, it's important that the court does not require that EPA find endangerment and therefore trigger the regulatory requirements. But its opening assertion that greenhouse gases are causing climate change makes pretty obvious its view that the science supports an endangerment finding. The court barely disguises its frustration with an agency that has refused to address what the court views as a serious risk in the face of a statutory provision that mandates, the language is shall, agency regulation of emissions that are found to endanger. Now, it's that frustration, born of the court's sense of injury, that Justice Scalia hones in on in his dissent on these merits issues. He finds in the definition of air pollutant sufficient ambiguity to defer to the agency's determination, i.e. the determination that there's no authority. And similarly, he finds nothing in the statute that requires the administrator to make a judgment on endangerment or that limits what EPA may consider in deciding to defer making a judgment. Scalia ends his dissent with a coda that captures the tension between environmentalism and institutional restraint that I think is the organizing theme of the entire case. And I'm going to read it just because it's such a nice summary of this theme. This is Justice Scalia, I'm quoting, "The court's alarm over global warming may or may not be justified." He's not taking a position, expressing some skepticism, "but it ought not to distort the outcome of this litigation. This is a straightforward administrative law case in which Congress has passed a malleable statute giving broad discretion not to us, the court, but to an executive agency." Now, it's not obvious to me what effect Massachusetts v. EPA will have on EPA. The court has remanded the matter for further consideration by the agency, but it has not dictated a result, and it has not set a specific time deadline by which the agency must act. EPA, for its part, has said it respects the court's opinion. It's good. But what else could it say? But it will take time to figure out how to implement this opinion, and we can imagine that it will take a long time, perhaps and likely through the end of the administration at least. But even if this or a future EPA did find endangerment and thus accepted the obligation to regulate, it's not clear what extent or to what extent an effective national climate change program could be assembled from existing EPA authorities. Also, the statute doesn't provide for international arrangements that will certainly be necessary to deal effectively with climate change. So further action by Congress and the President will be necessary to have a comprehensive climate change policy. So the holding itself may be of limited utility in actually solving the climate change problem, which brings me back to the symbolic significance of the opinion. The court has accepted, indeed it has seemed to internalize the beliefs, assumptions, and values of the environmentalists on climate change. It has legitimized the environmentalist concerns against the efforts of the administration to discredit and put aside those concerns. The decision provides a rallying point now for climate change advocates and a touchstone for the public on this issue. I'm not saying that this is the Brown v. Board of Education for the environment, but it may be as close as we will ever come. There remain the dissenters' claims that the court has exceeded its institutional bounds and stepped into a policy role for which it is unsuited. Commentators will disagree on whether the court got this case right or not, but I don't think the court has usurped the agency's role. The court did what courts do. It marshaled the facts. It applied precedent. It interpreted statutory language. It stopped at least one step short of dictating policy. Indeed, if you read the remarks of EPA's administrator after the decision, the agency has lots of discretion left on what to do on remand. But the court did show its colors, and its colors were green. At this moment, that is the remarkable thing. Thank you.